Well, welcome everybody. My name is Marty Mascari. I'm with the North Central Texas Area Agency on Aging and the North Central Texas Aging and Disability Resource Center, or ADRC. The ADRC is a project under the Area Agency on Aging. I'm a contractor with them. And we're here today. We're blessed to have Haiman+Hogue with us again for our partner, for a great partnership. And we're here today to talk about estate planning secrets of the rich. And we've got Sheila Williamson and Rex Hogue here to help cover that topic. But before we get going, I want to make a point. In the bottom, you'll see on the flyers that we sent out that it says that we're providing CEUs for nurses. And today's will not cover nurses. When the presentation was submitted, the CEU provider didn't feel like we met the threshold for that, and so we're not going to be able to provide CEUs for nurses. But Sheila will talk about what they can do here in just a minute. But since it says it on the slide, I want to make sure I cover it. So if we can advance to the next slide, I'm going to turn it over to Sheila to talk about the CEUs. And then when we're done with that, we'll let her introduce Rex. I have one note that I need to make on the next slide once we get there. So Rex, there you go. It's yours, Sheila.
Well, good morning, everyone. As Marty said, every time we do one of these, they are covered, the CEUs are covered for nurses, social workers, and it's any kind of nurse, LVN, RN, any kind of nurse, social workers, assisted living managers, and licensed professional counselors. But our guarantor with all the licenses felt this particular presentation didn't have enough medical threshold in there, I guess, to qualify for nurses. So what she told me, and this is something I have done for therapists before, is if you are a nurse and you do want to submit this for a CEU, then you go ahead and email me just like you would any other time, and I will send you a social work one. And then you can submit it yourself and explain to the people, you can show them the eval, explain to the people what the topic was, and then they can see if they will accept it. And I'm sorry, I did not learn this until Friday afternoon. So this was one of those things that this has never happened before, but all of our other CEUs are good for all of these people. But in this case, this particular one, she felt like did not cover enough medical threshold. So we are going to talk about some medical things coming up that I guess she didn't feel like it was enough. So I don't know. But anyway, how you do that, Marty, I've already sent Marty the eval and the sign-in sheet. You can either email me directly at sheila@haimanhogue.com, or you can wait until Marty sends you those two forms, send them to me. Either scan them in or take a picture of your phone, whatever you want to do, get them to me in an email, and then I will email you back your certificate. It's just that simple. But the last thing I want to say to you is, remember, what we're doing here is strictly educational. We are not selling anything. We are not promoting ourselves. We're not doing anything. We're strictly educating you. And education is our primary core value at Haiman+Hogue, and that's what we strive for. So we hope you enjoy this.
Real quick, I'm going to also add that there is a Google survey as well that should pop up as you log out today from Zoom. But if it doesn't, that link will also be in the follow-up email along with Sheila's forms. But we're asking you to fill that out, asking everyone to fill that out. That is comes from our funding sources for our goals and objectives that we put in our RFP when we applied for our funding. So so if you please fill that out, that would be great. Sheila, I'm going to let you introduce Rex and we'll get rolling.
Today, you have the distinct privilege of hearing the founding partner of Haiman+Hogue, Rex Hogue. And why is that such a privilege? Number one, Rex's schedule is crazy. He is the trust guru of this whole area. He writes the documents for Wealth Counsel. He's known by other attorneys as the trust guru. So he loves to educate. He just has to work it into his schedule. So he has wanted to share this with you because right now we're in a, with the market, the stock market and the world in an uncertain time, you need all the tips and secrets that you can get. And so do everyone. So anyway, we just thought it was a perfect time to offer this as some hope and something to look forward to. So without any further ado, our favorite trust guru, Rex Hogue.
Welcome everyone, I'm Rex. Estate planning secrets of the rich. I'm going to tell you that there's a whole lot more to estate planning than about money, and you're going to see that today. But these are things that we can all benefit from. Now, I always start with what I call the planning dragons. The first class of dragons is administrative dragons. This includes power of attorney failures, guardianship and probate, and medical documents. And that is the green dragon that runs around on the ground. And before the day's over, you'll understand why I call these dragons. Then there are tax dragons: capital gains taxes, gift, estate, generation skipping taxes, business entity taxes. There's a lot to the tax dragons today, or two tax dragons, but we're not going to really focus on that. We're going to talk about it a little bit, but not a lot. And that's that scary fire-breathing dragon that reminds everyone how much fun the IRS is to deal with. Then we have predator dragons, predator and creditor claims, and we're going to talk about protecting yourself and what you leave others. And frequently in lawsuits, what lawyers hear is, this just came out of nowhere. Well, I'm going to show you today, lawsuits don't come out of nowhere. There was some hint that they might be coming. We're going to start with our administrative dragons, and I'm going to start with the 6 key medical documents that really everybody over 18 needs at least some of these. The HIPAA patient authorization, that's a document that allows your authorized agents to gather medical information, and it's very difficult to make good medical decisions if you don't have the information. Then comes the medical power of attorney that authorizes someone to make decisions on your behalf if you are not able to. We have a personal and healthcare instructions document that gives you a chance to explain to your family what you do want. One of the things that I hear people say, I would want to do what mom or dad wanted, but this was not a topic we talked about around the dinner table or on vacation. Well, we've thought these through, and we've come up with this document that gives you a chance to say to your family, this is what I would want under these situations. Then comes the directive to physicians. Now, those first 3 are important, even for somebody 18 years of age. These next ones, maybe not so much for 18, but the directive to physicians, also known as a living will, authorizes the doctors to pull the plug if you are terminally ill. The anatomical gift forms, there's 2 things on it in Texas. One, whether you want to make anatomical gifts, and if so, how do you want to do it? What parts, what can they be used for, who does it go to, that kind of thing. And then the second thing that's on it is how you feel about an autopsy not required by law under the state of Texas. If you don't want one, you have an opportunity to say that on that form. The disposition of remains form authorizes somebody to make final arrangements for you. The medical form service, we use a company called DocuBank. I tell people that DocuBank is a fantastic service for less than the cost of a Starbucks coffee or a soda a week. They will have these documents that they can send 24/7, 365 to any hospital in the world. And one of the key things about having these documents is getting them to the right place when you really need them, and that would be to the doctor or hospital. Now, dealing with incapacity, I've talked about the medical side of it. Now I'm going to talk about the financial side of it. And you're going to see that there's actually some medical aspects to the financial side. The powers of attorney. First, a principal gives an agent a power of attorney. It's an invitation to third parties to allow the agent to act. Now, like any invitation, they can either accept the invitation or they can refuse it. I'll talk a little bit about reasons that people refuse powers of attorney, but they don't work as well as most people think they do. If they don't work, that raises the question of what's Plan B. A guardianship is a Plan B. That is defined as the court-supervised management of assets for somebody who is legally incompetent. It's sometimes called a living probate. The other Plan B is a living trust. It replaces the power of attorney, provides that necessary substitute signature. It avoids guardianship and probate, and it can even provide instructions for the incapacitated trustmaker's care. The guardianship and probate are caused by the same problem. Guardianship and probate are not the problem. The problem is a person is unable to sign documents so that they can either manage or transfer assets. Now, for some reason, people can vote when they're dead or incapacitated, but they can't sign documents. Guardianship and probate solve that problem by having a judge authorize a substitute signature. Sometimes they are a way, but sometimes they're the only solution to the problem. So my question is, are these the best solutions to the problem? The guardianship, basically, it's one of those 12-step programs that nobody really wants to be in. The minimum cost is going to be $95,000 to $30,000 or even more initially. The annual cost is typically $2,500 minimum, but it's usually more. It seems like a constant stream of surprises that goes on for as long as the ward is alive. It's disastrous for otherwise good business, estate, and asset protection planning. Guardianship leads to a lot of time. It takes months to get one in place. It costs a lot of money. You're going to pay at least 2 lawyers, a doctor to write a report. It's cheaper to go see a doctor than it is to get them to write a report, and a social study, and those come out of that ward's estate. There's a lot of going to court. It usually involves multiple hearings with at least 2 lawyers, and basically the person loses control of their life. They lose control of a lot of things, their assets, their life, and dignity. Completely lose their dignity. It's embarrassing to have your family members in court say that you're incompetent and can't manage your stuff. It's also a major asset protection problem because it opens the door for creditors and predators that otherwise would be shut. And that's one of the ways that Planning Secrets of the Rich, I'll show you how they avoid this. I'm going to give you an example. Carl and Myra have 3 children, Peter, Paul, and Mary. They have a $500,000 home, a $500,000 IRA, $1.8 million in investments accounts managed in Carl's name. They have a $200,000 joint bank accounts. Myra is terminally ill. She can't manage assets or herself. And Carl has Alzheimer's. Well, Peter, Paul, and Mary have discovered that the powers of attorney have failed. So what they need is to get the assets to provide for Carl and Myra, and there's plenty of assets here. But they have to sell the house because it's no longer feasible for either one of them to live there, and neither one of them is resisting that. They need funds for Myra to be in a facility. Carl is better off in a facility, and he's not resisting that. They started this process 4 months ago, but they still don't have the ability to do any of this. So they've got to get a doctor's report for Carl, hire an attorney to file guardianship application, notice interested parties, which in this case is the kids. A judge appoints an attorney ad litem who looks out for Carl's interest. A court investigator does a background check on Peter because that's who they're proposing as the guardian. Peter has to undergo approved training. The courts may be backlogged on background checks. During COVID, in some cases, we found it was taking courts 8 or 9 months to get to the background check. And meanwhile, there's no access to financial assets or info. So think about how that affects the kids. If they can't pull out of their own pocket the money to cover these things, what are Carl and Myra going to do? And until those accounts are accessed, the kids have to pay to maintain the house. They got to pay bills, including medical bills, and they got to provide the care for their parents. Then, under law, Peter has to have a bond up to 3% of the assets. I don't know if you added all that up, it's about $3 million. That's up to $90,000 a year to have a bond. That can be a real problem for the family. And Peter has to pay this until he can be reimbursed. A judge appoints a social worker for social study. Some of you social workers may have done that sort of thing. Next is a hearing, and if there's a pandemic, there can be a background check backlog, and sometimes even hearings get postponed because courts don't want to do them in person. Now, under a guardianship, any assets that's owned individually or jointly, like their home, on incapacity, you can wind up in the probate court for either a guardianship of the estate, which is very difficult, or a guardianship of the person, which is a little easier. In fact, it's a lot easier. Now, if they had a trust, here's the other plan B. You still have the problem of incapacity, but the trust, the assets owned in the trust, replaces powers of attorney. The trustee holds legal title to the assets, and the agent does not. It can avoid guardianship, provide instructions for care. Successor trustee manages. It's easier to manage, maintain, and change and update. But it works best when the assets are fully aligned with the trust. Now, I'm moving to what happens on death. Everything goes through what I call the estate settlement cost funnel. There's administrative expenses that come out, and it raises 3 administrative issues. Which rules apply? How many different rules apply? And where do you put your family in this process? Then there are probate expenses. There may be creditor or predator expenses, and then there can be taxes that come out. And if you have to file the Form 706, which is the estate tax return, administrative costs and the time involved are going to increase considerably. So I think of these like spigots out of this funnel. You turn them on and you pay for whatever comes out of it. And then when you're finished paying for it, the family gets what's left. Now, there are 4 ways that assets pass upon death, and only 4 ways. The first is joint with right of survivorship. That passes directly to an individual survivor. Then there are beneficiary designations and transfer on death designations. I refer to those as planning by the box. Why? There's a little box there that says, what do you want to have happen to your assets if something happens to you? And whatever you put in the box, that dictates the rules. If you put an individual, it passes directly to an individual. At that point, I'm going to show you on the next slide that you are now playing by the same rules as right of survivorship. And as simple as these look, you can lose complete control over the assets, and they both blow any tax planning that may have been done. If it doesn't pass by these 2 methods, we ask, is it owned by a trust? If so, it passes according to the trust terms. If it isn't owned by a trust, then the only thing left, it's owned by an individual, and that estate goes through probate, where it's controlled by the will or intestate succession. Now, for those of you who don't know, intestate succession is the will our state legislature has graciously written for you in case you either don't have a will or the will you wrote is not valid. Now, that will, if you have a trust, will pay the assets to the trust so that the trust ultimately controls the distribution. The box, you can name the trust as the beneficiary in the box, and the trust will control the distribution. The box, should all else fail, the probate estate becomes the default for it. Now, while all 4 of these get assets to beneficiaries, they're not equal in the way they do it. So let's take a look at the rules. The very first thing is that you should know that regardless of what method is used, you always have to deal with case law, the banking regulations, and the Internal Revenue Code, and really I should add, and the Treasury regs. Now, right of survivorship, beneficiary designations, and TOD all have a common set of rules. In each state where owners, survivors, beneficiaries, or assets are located, we have 4 laws involved, but you should know that the Internal Revenue Code has special bad tax rules that apply to assets passed this way. Then those state laws are going to be the Estates Code or the Probate Code, the Property Code, the Insurance Code, and the Family Code. And conceivably, there could be other laws that could come into play with perhaps unusual facts. If it's owned by a trust, we have one set of rules, the Texas Trust Code, assuming it's a Texas trust, or whatever state law does apply, that trust code would apply. If it's owned by an individual, then in each state where they own a real property interest, you've got the Estates Code or the Probate Code, the Property Code, and you go through probate. Now, if you take a look at this page, it should be kind of obvious that the simplest way to administer an estate is under a trust. One set of rules, one state law involved. Every other way of passing it is going to involve multiple laws and or probate, perhaps in multiple states. And I'm going to give you a case that shows this. Overusing right of survivorship and beneficiary designations, bad idea, leads to the wrong results, and most people just don't really know how this works. Now, probate technically means to prove up the will, but I like the layman's definition better. It's the court-supervised transfer of assets for someone who has died. People always want to know 2 things about probate. How much does it cost, and how long does it take? Well, if you call a law firm and they will give you a straight answer to that, run. They will lie to you about other stuff too. I'm going to show you there is no possible way to know that. Nobody can honestly answer that question on the front end. What you should ask, if you knew to, is who gets paid first in probate and who controls the process? Because as you're going to see, that affects how long it takes and what it costs. So the very first thing under Texas law, funeral and last illness up to $15,000 each if the court approves. Now, when you see little phrases like if the court approves, that means that lawyers go to court to argue over what the court should approve. Read that as that's expensive. Then there's a family allowance up to 1 year if there are qualifying family members. Then comes the cost of administration. Now, this is actually our favorite part of probate because that's where attorneys get paid. But this is misleading. We don't have to take a case until we've been paid. But this area includes court costs, executive fees, preserving safekeeping, managing the estate, and unpaid guardianship fees. Next comes secured claims and tax liens, unpaid child support interest, and then taxes, penalties, and interest. I heard you all cheering. That means y'all got it. In Texas, the IRS is number 6 on the list of who gets paid. Hey, deal with the IRS as much as I do, you'll realize that's actually a good thing. Then if the person was ever in jail or prison, which is fairly rare in our experience anyway, the cost of their confinement comes out of that estate. And then any repayment of medical assistance like from Medicaid. And then comes other claims. Now I'm going to give you an example of a weird claim nobody ever thinks of. A guy has a rental home, and we manage this probate, by the way. He died 1 month after signing a lease for a year. Well, the renter had more knowledge of this than apparently the landlord, and he told him, hey, I owe Joe Blow the money, but Joe Blow's dead. I'll write a check to his estate for rent. Well, the family, it took them over a year to be able to get that estate open where he could pay rent. Now, in the meantime, they had to pay maintenance costs, taxes, insurance, all of that, and they could not access the money for the rent. Now, at the end of his year, did the renter up and leave? No. He told them, hey, I'm putting the money in escrow. I'll sign another lease. Well, they felt like they didn't have a choice, so they signed another lease. About 2 months later, they finally got control, and they got one big fat lump sum check. Now, here's the problem. Probate was the cause of that. The guy knowing that, hey, John Doe is dead, I don't have to pay somebody else until John Doe's estate is settled. That's the kind of thing that drives people nuts in probate, and it shows you who controls this process. It isn't the courts. It isn't even the lawyers. It's people on this list who may make claims. Now, here's the good news. When all of that is paid and the family is no longer frustrated by lack of control, well, you'll notice the family's not on the list. They are last on the list. And who controls the process is all these people on the list. So I tell people, even though Texas has arguably the best, most efficient probate system in the state, this is Texas probate. I mean, in the country, this is Texas probate. If things go wrong, it's a horrible place to be. Probate is really a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. You know what? In talking to people, not one of those people is on the list of people they really want to look out for. And I've asked probate judges, do they agree with my definition? And they all do. Now, I've given you a little bit of information about probate, so I'm going to show you how this works in a case. Merlene died on a Sunday. Her 3 kids, Harry, Don, and Norma. Norma came to us the following Monday, 8 days after her mother died. She wanted to probate Mom's will because the real estate market here was very hot. I'm going to show you that. She wanted to open Merlene's probate. So we told her on that Monday, hey, here's a package to fill out, get it back to us within 48 hours. We'll have it ready to file in court. Norma was highly motivated. When we showed up on Tuesday morning, she was there, her 23-page package all filled out. It was complete. Well, I looked through it and I discovered that 20% of the assets were going to pass through her will. She had a home here and a property in Wisconsin. That will did not control anything else. 80% passed by right of survivorship, transfer on death, or beneficiary designations. Both of their sons were in second marriages, so we asked a question. How did Mom like her new daughters-in-law? The answer, she didn't like either one of them. We also noticed some other things that I'll go through the facts of each kid. But what happens when? Well, for Norma, she's in Texas, first marriage, she has kids, no issues. The hot real estate market explained her hurry. She can't sell the Texas real estate until after the Texas probate. And that can take a lot longer in a pandemic, but you're still looking minimum 2 to 6 months, assuming the courts aren't dragging these out by many months. And they can't sell the Wisconsin real estate until after the Texas probate and then the Wisconsin probate. So of her third, 80% goes to her outright within a month, but no protection. Harry, he's in a second marriage. He has minor kids from a prior marriage. Now, he died 10 days after his mom. We called Norma on Thursday morning to get her to come by and sign documents, and she didn't answer the phone. The reason is on Wednesday, her brother died, and she went to Illinois for the funeral and told us somehow she managed to leave her phone. So she didn't realize how easy we are to look up on the internet. But of his 1/3, 80% passes outside of the will. And look what happens. Under right of survivorship, it vested in him 5 days after Mom's death in both Illinois and Texas. So at least those two laws lined up, so we didn't have a conflict of laws. The beneficiary designations immediately vest. So that raised the question, what was his plan? Well, he had a simple will with his new wife, giving everything to her. Remember, mom did not like her. But what about his minor kids? Well, he didn't survive the 30 days from the will. That means that 20% of it is going to pass after, through the will, and it's going to go to the minor children, but they're going to go through a guardianship. Now, that guardianship is going to be under Illinois law, but here's the good news for those kids. At 18, they get the money. Does that really sound like a good idea? It isn't. Merlene lost 100% control over what went to Harry. 80% of it went to a wife she didn't like. The other 20% goes through 2 probates and a guardianship. Don. Now, Don has an interesting story. Norma actually dropped Don's family off Monday to the airport before coming to see us. Well, he's in a second marriage also. His kids are adults, though. Of his third, half of it passes by right of survivorship and TOD. 30% passed by beneficiary designation, and the rest passes through the will. Now, he has a message from the bank when he gets home that he needs to open a new account. On Tuesday, before he leaves the house to go open that new account, he receives divorce papers from his wife. Somebody served process on him, and so he spends the day getting the lawyer. On Wednesday, Harry dies. So unbelievably to me and the family, Don went to the bank on his way to Illinois. Instead of taking time to open a new account, he put his inheritance into a joint account with the wife who is suing him for divorce. Wow, I just could not believe it. Well, we looked up Wisconsin family law, and under Wisconsin family law, she gets 1/3 of it. It's his separate property, but she's now entitled to 1/3 of it because he put it in the account. Merlene loses control over 1/6 of this. Here's what a trust could have done for her. First, all the assets would have passed by trust under terms more favorable than the other methods. It would have avoided probate in Texas and Wisconsin. Norma's would have gone all to her. It would have protected her from existing creditors, future lawsuit creditors, and divorce. Harry's would have gone all to his children. It would have avoided guardianship. It would have provided for their college education. It would have protected them from existing creditors, future lawsuit creditors, and divorce. And they wouldn't have gotten it outright at 18. They wouldn't have gotten control of it until much later in life. And that way, instead of a nice car at 18, they get a college education. Far better deal. Don's would have gone all to him. It would have protected Don from his existing creditors, future lawsuit creditors, and that divorce. His wife would have been entitled to nothing. Now, trust, while the trust maker is alive, they avoid guardianship for the assets in the trust. It can provide instructions for care in case of incapacity. If I have time, I'll share a story with you about that. It can give you a chance to see how the successor trustee does managing the assets. That can be important to people, especially if they have adult kids who are going to do it and they don't really know how good those kids are with money. They can see. It's easy to manage, change, and update, but they work best if the assets are fully aligned with the trust, meaning the trust is funded while you are alive. Now, what do we mean by align assets with the trust? Well, here's how it affects the successor trustee. What we mean is that all of the assets are either owned by the trust or they pass by the terms of the trust. The successor trustee may need to go align these assets with the trust if that hasn't been done while the trust maker was healthy to do it. Managing assets outside the trust may require court oversight, and it certainly could lead to it. Courts are not where you want to be. The lack of asset alignment makes administration more complicated. Trustees have to know and apply the multiple sets of potentially conflicting rules. And I didn't really talk about that, but these different states, their rules may vary from one state to the next. The trustee is better off aligning those assets to use one set of rules, avoid guardianship and probate to administer the trust. In fact, they could even be held legally liable for not doing that. Now, how does this apply to people who are not rich? Well, everyone can keep their affairs private. That's something rich people do. Rich people understand what actual control of assets is versus ownership. You can own your house, but if it becomes subject to a guardianship, you don't control it. So it's amazing to me how many people think, oh, I own it, I control it. No, control is something totally different than ownership. It's the incapacity plan B. It avoids guardianship. You can choose between guardianship and a trust. These days, almost everybody can afford to do a trust. It avoids death administration dragons. It avoids probate. Now, we're going to deal with tax dragons. Tax dragons are those nasty fire-breathing dragons. And while I'm focusing on the IRS, they are not the only tax dragons out there. Now, a few years ago, the IRS went through a phase where they called themselves the new, friendlier IRS. We had a tax case against them, and I'll just show you this is what I thought. They didn't look any friendlier to us. We dealt with them enough to know it was the same old IRS. But this guy's saying, hey, you'll be pleased to know I'm using a poly Teflon blade for a smoother, less irritating cut. The IRS has become more efficient. Their computer system now is at least late 20th century, maybe even early 21st century. They can track things like they haven't always been able to do. And make no mistake about it, folks, the IRS is only in it for the money. The IRS declares war on your family. They like to bring their ship into your harbor. We like to call this ship the IRSS Your Money. What this ship is missing, I know what you're thinking, sails. Yes, again, it's a pirate flag. They're there for one reason, and that's to haul your money off to the U.S. Treasury. They are very good at it. Your family has two choices, and the choices will depend on what choices you leave them with. They can raise a white flag, get out the checkbook, and write the IRS a check for whatever amount the IRS says. Most people don't like that plan. They would prefer to fight. But in order for them to be able to fight, you have to leave them a plan. See, the United States has two tax systems. We have one for those who are uninformed or unwilling to act on what they know. We have another for people who are either educated or who seek wise counsel and who act on that education or advice. Which category are you in? Perhaps more importantly, which one do you think pays less in taxes? It's the second one. They pay way less in taxes. Now, under the American Taxpayer Relief Act, which is called the American Taxpayer Relief Act of 2012, even though it wasn't signed until 2013, don't ask me how the government comes up with names like that. Married couples under current law have a $12.06 million permanent exemption. Now, the way portability works is a surviving spouse can pick up any unused exemption that the first decedent doesn't use. Now, this is a great tax tool, never was available before. So if the husband dies first and he only uses half of his exemption, the wife gets to pick up the other half of that exemption and add it to her own exemption. But to do this, you do have to file the Form 706 and go through the estate tax return. And just remember what I said earlier. That means that you're going to spend more money and take more time. If you don't file the 706, you don't get the portability. Now, here's the way a plan like this works. Community property, the husband's separate property, the wife's separate property. They can use these to take care of the other while they're alive. The AB plan, which I'm going to show you in a minute, allows the survivors to benefit from both sides. Then the B share goes to the decedent's beneficiaries. It prevents disinheriting any children. It reduces friction in second marriages should the surviving spouse get remarried, because once that happens, it is possible for the kids to get cut out. Well, they won't get cut out of the B share. The B share is not part of the surviving spouse's taxable estate, so it's not subject to estate tax. It removes the growth from the B trust from the survivor's estate. It avoids capital gains taxes on both deaths in most cases. Not always, but in most cases. And then when one dies, separate property assets can go for multiple purposes. Here's how the AB plan works. One dies, we divide it into an A side for the surviving spouse. A actually stands for the above ground spouse. It may shock you to hear that B actually stands for the below ground spouse, but it allows us to use both estate exemptions. Now that's estate tax, but there's some other tax strategies. So there's business taxes. Separating real estate from the business can allow you to do a couple of things. Better asset protection, but you also get to take advantage of two different tax entity styles. Separate businesses from each other. You can get life insurance out of the taxable estate. I had a client with a yacht one time. We put the yacht into a family limited yacht partnership, and they were paying for the yacht on their own, and we told them no more free rides on the yacht. Now you're going to rent it. I'll never forget this lady. They had a lot of money. She looked at me, literally puts her hand on a hip and says to me, "And where are we going to get the money to rent that yacht?" Well, I explained to her, you're going to rent the yacht from your FLP, your family limited partnership. And now the money you spend on it will become tax deductible. Shortly after that, the CPA informed me that amounted to a $400,000 tax deduction that they were not taking. And by the way, one of the biggest mistakes we made on that case, we forgot to charge them for that tax planning. Then they filed the 706 on the first death to maximize benefits for the family and take full advantage of the tax law. Now, don't get me wrong. We don't always suggest filing the 706 on the first death. A lot of times we suggest not filing it. But there are times when it makes a lot of sense to file it. But it also makes sense to coordinate this with gifting strategies. Some other strategies they can use are discount planning. Let me give you an example. Let's suppose you wanted to buy a piece of property that I own, and let's say you were willing to pay me $1 million for it today. And as we're getting close to getting this deal finalized, I tell you, well, actually my partner Fred owns 1%. So I can only sell you my 99%, but I want you to pay me $990,000 for it. Well, after you talk to your lawyer, you realize, hey, Fred has the same right to use it that you do, and you can't charge him rent. Does that affect how much you're willing to pay me? It should. That is called a discount. You're not going to pay me $999,000 because you don't control all of it. But there can also be entity restrictions. So if we put it in an LLC, perhaps those membership units will be discounted because we have restrictions in there that you don't have complete control over it, even at that. Now, I'm just going to give you an example of a case that we worked on last year that involved real estate. We got combined about 65% in discounts. What that meant is that $1 million asset is taxed as though it's only worth $350,000. Now, when the estate tax is 40%, 40% of 250,000, of 650,000 is about $260,000. That's real tax savings to the family. There's also charitable planning. Rich people coordinate their charitable planning. You can do that in two ways. You can do direct gifting, or you can get something back. Now, that's more expensive planning, but in terms of getting assets out of your estate, they both work the same way. Here's application to non-rich people. Something rich people do, they always hire professionals. There's a lot of amateurs out there who claim to do estate planning. Not everybody really does. Less than 1% of attorneys practice in this area truly. They learn the tax rules. You can know the tax rules. You're getting some education today. Obviously, there's a lot more to tax. I could talk for hours on tax and not tell you everything you might need to know. They apply the tax rules. Guess what? Generally, regular people can too. They act on the tax rules. They'll use multiple tax strategies. You don't have to use just one, but you don't have to use everyone out there either. Every case is different. Now, asset protection, our predator dragons. First, asset protection is defined as protecting and preserving assets from unnecessary loss. Now, there's multiple aspects to that part of it, but what a lot of people want to know is how do you avoid being a victim of the lawsuit lottery? And I'm going to show you a lawsuit lottery case here in a little bit. The biggest risk to your estate plan is probably going to surprise you. It's your child's spouse's divorce lawyer. If your child is married and there's any chance they could go through a divorce, just be aware your child's spouse's divorce lawyer may be your biggest enemy if you don't plan for them. Beneficiary debts, that can be a problem. Extraordinary bills, especially medical bills. Now, I'm going to give you an example of this. A friend of mine who grew up on the street I grew up on, about 1.5 years ago, she was putting something up in her cabinet. She stepped one step up on a step stool, fell and broke her leg. She was in the hospital for 12 days. The hospital bill was over $300,000. To get her repaired, she's had surgeries. I don't know the exact cost, but $500,000. I guess that'll teach you to put dishes up. I tell my wife that's dangerous for me to do, that you can't afford for me to do that. She doesn't buy that though. But that's an example. Imagine her parents had just given her $500,000, which could make a huge difference in her life, but it would be gone if they don't do it the right way. Predator threats, future lawsuits is what we're talking about. So here we're going to ask questions. Does a beneficiary have a high-risk lawsuit job, like a doctor, just as an example, or a lawyer? What state does a beneficiary live in? States vary about their asset protection features. Texas is a great asset protection state. California is not. How would the loss of those inherited assets affect your beneficiaries? So these are things that families need to think about and plan. And yes, regular people can do them too. And this is one of those cases where this dragon just comes flying out of nowhere. People don't map it out. Then the beneficiary receives property. There's multiple ways that this can happen. The most common way is for people to pay it outright. If that's your plan, you are not protecting your beneficiaries from anything. lawsuits, guardianship, probate, all of it comes into play. You can leave it to them in a convenience trust. That provides some limited protection. It at least keeps it as their separate property, and it can at least avoid guardianship and probate. But it isn't going to protect them from their own bad money management. It may protect them from estate tax. It might protect them from their own bad money management for a period of time, but it doesn't protect them from other things. The third way you can do it is something like a heritage trust. It offers full protection. It offers everything the convenience trust offers, plus creditor and lawsuit protection, bad marriage protection, bloodline protection, and even protection against the loss of government benefits, and ultimately estate tax. Under Texas law, we can preserve it from estate tax for 300 years. Now, I tell people, am I worried about that in the future? No, because I'm planning to retire within the next couple of 100 years. Folks, that's generations away that you can protect and keep the IRS from taking another bite at the apple. Now, this is a story, took place in another state. I'll get to the state in a bit, but Carrie was a young lady. Her parents passed to her $3 million in her inheritance. She got control of it, and she was involved in a car accident. Somebody tried to go around her at an intersection, caused her to, they hit her, caused her to veer off. She T-boned a van load of daycare kids, and it killed a driver and 2 kids. There is a huge lawsuit over the accident. Well, the jury came back with a $9.8 million judgment. They found Carrie 10% liable. They found the guy who hit her 90% liable. So how much does Carrie have to pay? Well, under that state's law, Colorado, if you're 10% liable, under what is called joint and several liability, she had to pay 100%. There went her entire inheritance. And by the way, just for the record, she also had $1.5 million of car insurance that paid off. But it wasn't enough to pay that judgment. Now, a friend of mine actually was the guy who planned that case, and he asked the question, is there anything else we could have done? Well, one of my colleagues shared the story of Ted. Ted got a little bit too much elbow exercise one night. He failed to negotiate the bridge over the Chappaquiddick River, and as a result, while he got out of the car, Mary Jo Kopechne did not. She drowned. The Kopechne family tried to come after Ted Kennedy for millions of dollars. However, they ended up only being able to get what was in the car insurance. Why? Well, because the Kennedys did way better planning than Carrie's parents. Now, this is a multi-million-dollar case. I've shown it because a lot of you will be familiar with the Ted Kennedy accident, but think about it. Ted Kennedy's family could afford a much bigger loss than most of us. So, 3 questions. What are your risk factors? What do you own that's at risk? And how would the loss of those assets affect you? I'm sorry, I meant to make one more point about planning for your kids. The Kennedy family used what we call a heritage trust. Carrie's family used what we call a convenience trust. So the planning that you do for your family can have a long-term impact on them. Now, for yourself, these are the 3 questions we ask. What dragons are out there flying around? Well, if you know these 3 things, those lawsuits won't be coming out of nowhere. You'll know where they're coming from. And if you know where they're coming from, you can plan to avoid them. Now, there's 2 classes of risk factors. On the left are personal. These are things that, we all may have. Very few of us have a yacht, but boats are kind of common. But there's a lot of personal risk factors that we all have every single day. But then there's non-personal risk, professional services, general partnership liability, managerial liability, non-homestead real estate. There's all kinds of claims out there. Now, each of these claims is like a lit stick of dynamite. It's only a matter of time before something goes boom. Once you realize that's a lit stick of dynamite, you can start trying to diffuse it. But if you don't realize it's a lit stick of dynamite, you'll do nothing about it. Now, there are certain assets that are exempt and predators can't take them. Here they are. I'm not going to tick them all off, but your homestead while you're alive. But life insurance, annuities, those kinds of things. Now, here's the real question in a lawsuit. Do you have enough non-exempt assets, and that is exempt from bankruptcy, that a predator could justify their trouble to come after you? Because, folks, I can tell you, bringing a lawsuit is not cheap. They don't sue people who live in boxes under bridges because they don't have anything they can collect. Well, guess what? A lot of people have only these types of assets, and they're not collectible. Then there are non-exempt assets, non-homestead real estate, mineral interests, cash, CDs, brokerage accounts that are not IRA, 401k type of things. Receivables, money that people owe you, certain vehicles, boats and planes. They actually can be high-risk assets in some cases. Interest in trust, intellectual property, or business interests. All of those things are at risk. These are the types of assets that need protection. These are the pots of gold that you need to protect and preserve, and you need to plan for them. If the loss of all of those type of assets would have a devastating effect on you financially, you need to consider asset protection planning. So a lot of people don't always think of these assets the right way. They think of real estate, but it might be held, it might either be income producing real estate, or maybe you're holding it because you know land is going to go up, for example. Different ways to use it, but you need to protect them both. Then there's liquid or semi-liquid assets like cash, stocks, bonds, mutual funds. Maybe you saved it up for a rainy day, not for a lawsuit coming. Business, rents, and royalties. Now here's an example of predator claims. In fact, I'm going to give you some quick cases. Arlene is a widow. She owns her home, but she has 12 rent houses and $5 million in a brokerage account. She doesn't have any debt. She is well set. And then she hired a guy to put Christmas lights on her home. Unfortunately, he slipped and fell off the roof, and ultimately died. Now, you think, what's the big deal there? Why should she have to pay? Because it happened on her property. She owns that house. Somebody gets hurt on your property, they can sue you. Now, her homestead is protected. They can't take that away. But what about this other stuff? Suddenly she realized that those rent houses in that brokerage account were at risk. And unfortunately, she can't protect those. It's too late. The incident that leads to the lawsuit has already occurred. So, a lesson you can learn here. You have these kinds of assets, protect them. Don't wait until something like this happens. Mike was a business owner. Now I'm going to give you this quote from Sun Tzu, who wrote The Art of War. He said there are two ways to attack an enemy, directly and indirectly, but there's an infinite combination of ways to mix them. There should be quotation marks at the end of that, but I forgot to put them there. Now, direct or indirect management risk. Mike owned a company. Basically, they had a shop. He had two guys who had worked together quite well, working in the same area. 15 years, those two guys had worked together. But one day, They got into a fight, and within seconds, one of them was incapacitated for life. Mike discovered that because he was liable for the criminal act of the other employee, that he had to pay for the care of that injured employee. Now, fortunately, there was business insurance to cover that kind of thing, but I'm going to show you a case where they didn't have that kind of insurance. And that's something that most people wouldn't think about. You would expect them to have insurance if somebody got hurt, but sometimes that insurance wouldn't even apply to a criminal act, depending on the facts. But employers are vicariously liable for the acts of their employees. It's amazing to me how many business owners don't seriously consider this. Isolate your personal assets from your business risk. Now, before I share this next story with you, I'm going to tell you something funny that happened in my office a few years ago. We had an employee, and frequently I would send her out for lunch. And then one day my car was in the shop and she gave me a ride home. I never sent her anywhere to run an errand again because she was one of the craziest drivers I have ever been in a vehicle with. It was a white knuckle experience all the way home. And I realized, wow, her going to get me lunch is putting me at risk. So we quit doing it. Now, Mitch was a business owner. He had purchased something for his wife at the mall, but it wasn't ready. So he asked his assistant, Suzanne, on her lunch hour to go pick it up. As she was getting ready to go, Mitch said, "Suzanne, take my car. There's no point in you having the mileage." The truth is, Mitch didn't want to have to pay her mileage. Well, on the way back, she's coming back. She comes up to an intersection. She had never driven Mitch's car before. The light turns yellow, and in her opinion, didn't really give her enough time to get through the intersection. So she tried to hit the brake, but instead she accidentally hit the accelerator. She hit a guy named Dan. I was working for a personal injury firm when this happened. It happened when I was in law school. Dan was a surgeon. She broadsided Dan. He was lucky to have survived. But Dan was going to be out work for 2 to 3 years. Now, think about the implications here. What do you think Dan can get to? Well, there had been a hearing before I went to work there where Mitch claimed that his vehicle, we knew we were going to get to his vehicle insurance, even though he tried to claim he wasn't driving it. It's his car. His insurance still pays off. What about business insurance? He tried to argue that this had nothing to do with his business. But my boss had successfully argued, really? It was your employee. It happened during business hours, and you could tell her whether she could go or not. And Mitch didn't give her a choice, really. What about his personal assets? Well, he didn't have a business entity, so his personal assets are at risk. That would include what he called his retirement home and his large stock, bonds, and mutual funds account. Suzanne's car insurance is going to pay off. But there's one other thing that's going to pay off. That's Susan's personal assets. This is when the case took an interesting turn. See, it turns out that Susan's husband was also a doctor. Their asset protection plan was to put everything in her name. Wow. Then she's the one who runs over a surgeon. My boss took me to lunch, and I'll never forget 3 things he told me. He said, "This is a target-rich environment. There's no real planning involved. No one here has leverage. This is going to be Katie, bar the door." That case was ultimately settled for 1.6 times what we told Dan it was worth. That's because nobody had leverage. Now, people think asset protection doesn't apply to me. Here's a classic example where it can. To some extent, I'll even admit that Dan got lucky. The lawsuit lottery happened to hit a target-rich environment with no planning, no leverage, and got actually a lot more than he might have expected. Now, I've given you 3 cases of planning failures. Let me tell you about James and Michelle. They actually did a very good plan design. They used a living trust as a base. It was completely funded, so they got rid of the probate and predator dragons. The probate and guardianship dragons. They used an irrevocable trust for their kids to be part of this plan. They set up one LLC for their financial assets. They had a management company, and they had a separate LLC that managed their business. There was a lawsuit years later. In fact, they lost the lawsuit, multi-million-dollar judgment, but the creditor could not get through the planning that we had designed. Now, don't think that every LLC will do this. This was carefully designed. It was carefully designed for the risk, and we did a good job of planning. And James and Michelle were only out the insurance. Now, that is a case where good planning done long in advance, the real lesson learned is proper preparation prevents poor performance. Now, how can rich people benefit from this? Well, first of all, heritage trusts are a little bit more expensive when you do your planning, but they're not that much more. Generally, I'm not going to quote fees, but I'll just tell you that it's not that much more to add a heritage trust, and over 80% of our clients do it. They can do bloodline protection, keep it in the family bloodline. Now you may think, hey, I love my son-in-law and my daughter-in-law. That's great. But if your child dies first and they get some of that inheritance and they get remarried, it might go to your child's replacement instead of your grandchildren. Is that what you want? At the very least, you need to think that issue through. Some of our clients are using a little feature in the Heritage Trust that we call the Rockefeller Trust. That is that they're setting some of it aside so that the beneficiaries can only get the income out of it. They can't take the principal out. Now, they don't normally do it for all the assets, but some of our clients do it for some assets. They can keep assets out of the beneficiary's taxable estate. Now, I told you a while ago that under Texas law, you can keep it out of the taxable estate for 300 years. But right now, we can also move to other jurisdictions that keep it out of there forever. I hope Texas will become enlightened and do that, but they only recently did the 300-year thing. So that's progress. They identify personal risk and plan accordingly. You can do that too. They create structures that are difficult to get through. You can do that too. Now, sometimes I just tell people the reality is you may feel like you don't have that much to protect, and you might feel like the cost of protecting it is high compared to the benefit. But my question is, hypothetically, let's say you had a $250,000 asset you're trying to protect. And let's hypothetically say that it would cost you $25,000 to protect it. I think that's relatively high for that kind of asset. However, what does it cost if you lost it all? It costs 100%. So you have to think about that. And sometimes it's difficult because sometimes asset protection planning, it's definitely more expensive than not doing it. You also need to get others involved. For example, we always tell our our clients, get your kids involved if you can. You can set up an irrevocable trust for them. You can get somebody else to manage that trust and get a management vote. The advantage of that is you've got 3 people involved instead of just 2. And I can tell you, family lawyers and litigators will tell you that if the only people involved in this plan are husband and wife, They're going to go through it like a hot knife through butter. They're going to get through it. You can prevent that by getting other people involved. You can partition assets. Don't keep your rental houses and your financial assets in the same entity. You can manage asset protection planning like a business. That's important because they're always going to attack the way it was managed. Now, how to plan? We analyze your family situation, your financial situation. We determine your goals and objectives. We analyze which specific tools will work for your situation. We learn about your goals and objectives and then apply planning that can meet them. We consider what you're trying to protect from and what tools might work in your case. Folks, there is no asset protection plan that's a magic bullet. They're all different. Every case is different. But before planning, trust me, folks, there's dragons out there. They'll come. Eventually, one of them is going to come and snatch your assets, or at least there's a chance that will happen. After planning, guess what? The dragons are still going to come, but we've protected you by putting you behind a castle, you and your assets behind a castle. Again, the dragons will still come, but they've got to get through the castle, and you've got a knight to come out and slay the dragons for you. I want to thank you for attending. It's been a pleasure sharing this information with you. Hope I didn't go too much longer than anticipated, but I'm prepared to take questions.
You're great. There is a few questions. I don't know if Sheila's.
Yes.
Yes.
I tried to write them down in the order that I saw them. So anyway, the first one is from Antoinette Baker, and she is, it is about, Rex, she's confused about what you talked about. I'm going to read it to you. The state of Texas has a medical power of attorney, but you list a durable special medical power of attorney. In my career, I've never seen one of these. Can you please explain the difference?
That is the technical name that Texas gives that document. It's frequently just referred to as the medical power of attorney.
Okay, so it is the same. Okay.
Yeah, there's no real difference.
Okay, now then Deborah has, she said, it's a comment. Social Security does not recognize power of attorney, and you must have a doctor sign one of their forms declaring that the incapacitated person is unable to handle their affairs. Do you know anything about that?
Yes, it's one of the ways that powers of attorney fail, which is why I'm not a big believer in depending on them.
Okay. Next question is from Stephanie. What is the difference between right of survivorship and TOD?
The key difference is when it vests under right of survivorship, the person has to survive for, in Texas, 120 hours. And that actually came from a case where a couple were in a car accident, killed at the scene, but it hit the driver's side first. The husband was driving. They argued that in that split second of time that he was dead and she was alive, that title passed. The Texas Supreme Court ruled that's exactly how it works. Our legislature created a 5-day survival period that's required under right of survivorship. Under a beneficiary designation, it vests immediately upon death. That's a great question, actually.
Okay, now here's an interesting question, Rex, from Jasmine. What about cryptocurrency when it comes to estate planning?
Cryptocurrency is certainly something that you want to have your plan be able to control. And that's certainly an asset that you can put in a trust. I'm not quite sure if I can answer the question any better than that.
Okay. Now, next question is from Jean Marie. Being a fiduciary, can you explain what that means?
Yes, a fiduciary duty is the highest duty that our law recognizes that one person owes another. And if you are a fiduciary, and if you are acting as an agent under power of attorney, if you're the executor under a will, the trustee under a trust, you owe the highest duty to the beneficiary or the person for whom you're acting. And if you breach that duty, i.e., you are not looking out for their best interest, you can be held legally liable for it.
Next, this is from Sharon. If gold is purchased as an investment, how do I protect it under our trust?
Well, I'm not sure what she's trying to protect it from. It is an asset of the trust. There's the estate planning side. It would avoid probate and guardianship, but from an asset protection standpoint, that's a different issue. Gold, by the way, is very attractive to creditors and predators. So asset protection comes into play when you have gold. At least you ought to think about it.
Okay. From Denisa, when you probate I'm going to read the question as it says. When you probate a trust due to trustee mismanaging funds or breaching fiduciary duties, does the estate pay the cost of probate, attorney fees, etc.?
Okay, so trusts are not probated, wills are probated. A lot of trust litigation may be fought out in the probate court, which might lead somebody to think it's about probate. But that is going to depend on, in part, the outcome of the case, and in part, how the trust is written. Too many factors to give a straightforward answer on that, and I apologize, but there's just multiple ways it could happen. If the trustee is found to be in breach of fiduciary duty or found to have breached their contract, they're going to be held personally liable.
Okay. Is there a way to avoid probate without a trust?
There are ways that avoid probate. For example, right of survivorship, beneficiary designations. The problem is, as I showed, they're not reliable. They may not really avoid probate. They may cause the assets to wind up with people that you never intended those assets to wind up with. I can just tell you that there are, and by the way, we could actually offer this as a report if anybody was interested, 53 things you can do with a trust-based plan that you can't do with other plans. And we have a report on that. I'd be happy to offer that up if anybody emails us and asks us about it. I don't know what the rules are on that, Marty, but we can make that a handout if anybody wants it.
Okay.
Okay. And there's several that would love that.
Yes, and we can surely, if you just email that to me, I'll include that in the follow-up.
Okay. Yeah,
Everybody's-
we can do that.
Well, we'll make it available to everyone then. Yes. Okay, now there's more in. Okay. Oh, well, Amy, that would depend. She's asking how much it would cost, a ballpark figure, to get a trust in place, but really, I don't think we're supposed to answer that, are we, Marty?
Yeah, you would need to call an attorney, and obviously Haiman+Hogue would be, one of those potential attorneys. But again, we have to be careful that we're doing this for education and we're not selling. So that would be up to you to do outside of this.
Yeah, and if I may comment, don't look at cost alone, because it's like building a house. There's a huge difference between a mansion and a tar paper shack. And every now and then people will say, wow, that's high. but then they look at what it does and realize, but it does 8 times as much as one that's only half the cost. So you have to look at what they do. And that's true of any planning.
Okay, and one more question. In the event that I die, what will happen? This is from Anonymous. What will happen to my estate, pensions, Social Security, 401ks? Will my disabled son get it, and will he lose his SSI?
If it passes either by beneficiary designation or by the estate, if he is a beneficiary, yes, that is likely to cause him to lose his SSI. If you have an incapacitated child like that, I cannot emphasize how important it is to plan around that. I did not discuss that issue today, but you really need to develop an estate plan with that specific issue in mind, and the attorneys need to know that on the front end.
That is what you call special needs planning, and it can be done. Anonymous, it can be done, but your Rex is right. They have to know it on the front end, because SSI is absolutely, you cannot do that.
Yeah, you can really put them at jeopardy of losing their benefits.
Well, and it's not just the money benefits that they're losing. The main benefit that they lose is the services, the government services.
Yes.
I know this because my son is a disabled person. I know this. And you can't use their insurance. You can lose so many benefits that they have, and you don't ever want to do that. So, yeah.
Sheila, you've gone black on us.
Oh, I know. That's because. Okay.
Oh, it's all right. No, I'm not making you try your camera. I'm just telling you. That's all right.
Sorry.
Do you want to go ahead? Let's go ahead and review the CEU requirements if we could, because I know there's been a couple of people that have asked those in the question. So could we go to there should be the next slide.
Yep.
To go back to the CEUs again.
Marty, I'm attempting to forward the slide, but for some reason.
Yep. So just if you'll unshare and reshare. If you stop sharing and then reshare it. I've had that happen before too. It locks up. Let me
I'm not sure what's happened here. It has just completely locked up.
That's all right. I've had that happen to me too before. So let me see if I can get it from here. I do have the presentation pulled up here. Oh, I thought I did. Hold on.
Maybe I should try unsharing this way.
Now you've unshared. Now if you just share now, reshare it.
Okay, got it now.
There
wow, my apologies,
Perfect.
folks.
There you go. I've had that happen before too. It's not a problem. Go ahead, Sheila.
Okay, well, there are just 2 forms that I will need to get your CEUs. One is an eval form, and I know all of you are used to these, an eval form filled out, and the sign-in sheet filled out. And all you have to do is either scan them into me, or if you can't make that work, then just take a picture of them with your phone and send an email. Either way, it's Sheila@Haiman+Hogue.com. Very easy. Please send those to me, and then I will send you the document. Now, keeping in mind what we said first, if you are a nurse of any kind, RN or LVN, either way, then you're going to get a social worker one, and it will be up to you to submit that, because that's all.
There's no guarantees that they're going to take that. We just want to make the point of that, as we did right at the beginning, that the CEU provider, which is a vendor of Haiman+Hogue, has said that they could not put CEUs for nurses on this presentation, but they said some people have taken the CEU certificates in the past for social workers, submitted them, and they've accepted them, but once again, there's no guarantee for that. We're just telling you that that is if that's the case. So we want to remind you that this is not qualified for direct CEUs for nurses or assisted living facility managers.
And all the rest of them that we do is.
Yes.
Or are.
I see it now. It is in the slide, but it was after Sheila's email address. So we just make that point. The other thing too is there will be a Google survey as well that we do for for our funders. It should pop up when you close out of the webinar. If it doesn't, you'll also receive a link to that in your survey. In the follow-up email to that survey. And I do know that some people are having problems with even opening those surveys at their work. If you do, I encourage you to just forward that email to your home email address and complete it from there. I don't know why they would prevent that, but I know some companies have prevented their employees from opening those documents. So do we want to go ahead and advance to the next slide real quick? And we're going to talk about our next webinar, which is a rescheduled webinar from last month, which is in stages. And I don't know if it'll go. If it doesn't, that's all right. In stages. Here we go. I got to pull up. So I have the date. I'm sorry. It's on May 26th at 10 in the morning. We'll be doing in stages. Just so you know, if you signed up for this last month, you will automatically get the sign-in document. The links to access it. And I know some of you have signed up this month as well, but all of you will get the links to access this webinar.
And I see that because originally, Marty, this is very confusing to you, and I'm sorry. Originally, Marty was going to offer this through his organization, the CEU, but now we are going to do it. It will be available for nurses because this is a huge, hospice is definitely a medical situation. So obviously, it will be available for nurses, social workers, LPCs, and assisted living managers, all of them. And I will tell you this: we have great representation from all of you except the assisted living managers, and I don't understand that because I guarantee you they could all use this one. All of them could use this one. So, but anyway, because all we're trying to do is educate, and we're trying to make it better for our seniors. The more you know, the more people you can help. So anyway. Very good.
Very, very good. Rex and Sheila, thank you so much. This a partnership with Haiman+Hogue has been just incredibly valuable with just great feedback from the people attending these webinars. And we're so grateful to you for this education. We certainly appreciate it. Thank you all for joining us. Look out for the follow-up email. It will go out tomorrow. And I will get and create a link to the document that Rex referred to, and that will be in that email as well. Y'all have a wonderful day, and we look forward to seeing you at either on May 26th or any of the other webinars. Take care. Bye-bye.